Hopefully. Thank you, Dan. It's a hell of a mess we're in right now, insurance, and I've never seen the likes of it in my 39 years, and nothing close to this. And it's a combination of things been building up on the litigation end, and the storms, and then to have Surfside happen also. It obviously is affecting insurance too. We don't need the wind to blow too much anymore. Unfortunately, that's going to probably continue happening. I'm a delegate with Community Associations Institute's Florida Legislative Alliance, and visit Tallahassee the first week of November to meet with legislators and lobbyists before the session starts. Because once the session starts, things are rolling, and we wanted to get in early to see what's going on. So on the insurance side, I want to mention our local Pinellas Senator Nick DeGleese. Okay, that's DICEGLIE, Nick DeGleese. He is on the Senate and Banking Committee. I had an opportunity to sit down on a one-on-one with him in Tallahassee. He gets it. He understands it. One of the issues we're having with citizens insurance and a lot of our associations that have more than 50% short-term rentals is they can't get, and the private market is dried up for wind, they're not eligible for citizens. And a lot of them are going naked. They're not taking wind. And it's causing a lot of issues, obviously with lenders and others. So there's a statute that Citizens is committed to doing this to minimize their exposure and the business they bring in. And Nick is co-sponsoring a bill that will address that early on in the session. So it really would be helpful if he could hear from you if you've got concerns about insurance, because that's where he's focusing. And the legislatures focus on different things. So, I saw Representative Linda Cheney from St. Pete Beach. She gets it too. But her, Nick's focus is, because he's on Senate and Banking, Insurance and Banking, Insurance and Banking as a senator. So it's really important that, you know that, and please let him know that you're concerned. So the legislature last year passed the tort reform that's going to help us minimize, get rid of the litigation, the assignment benefits, the one-way attorney fees. So that got done a year ago, or last March, but that's going to take a couple years to catch up. Over 100,000 lawsuits were filed the 2 weeks before the governor signed that bill. Because the plaintiffs, the Morgan and Morgans, knew what was coming. So it's going to take a couple years to get through that, but that will help. But just understand the main issue with the carriers in Florida is the availability and affordability of reinsurance and the wind. Okay? So it's all about Irma, Michael, and Ian. Those three storms decimated the state program insurance, and that's why Citizens is back, as they know, no longer the carrier of last resort, but the carrier of, unfortunately, first resort for a lot of our associations. So that's what we got to deal with, these carriers, and find a way to help them get this done. So hopefully during the session, they'll come up with some ideas. I just heard yesterday a U.S. senator from another state, I don't remember where from, but it's starting an inquiry and investigation on the financial support and condition of Citizens Insurance, because they at the federal level are concerned that if Citizens can't deal with a major hit, then it'll end up with the feds and FEMA, and they're trying to minimize that. So they're looking at how that will work. And hopefully, I think Citizens is in pretty good shape. But again, it's all about if the wind blows again or not. And Idalia this past fall was all flood. That was not a wind event. And that's not bad or good, it's just that, that was more of a FEMA flood issue and not a carrier private market wind issue. So kind of that was good in that respect. We just, we need to be aware of, where we're going on that. So just understand, we're working on it. It's not, we're not gonna get any help on the premiums for a while. It's still gonna be a very tight market, but, work with your agents. There are alternatives, there are options. There's a new admitted carrier that we're working with that's killing it right now. So that's a good thing. And of course, Citizens is, still about half of the rate of the private market. And again, you have to do some things to get in there, but that's just kind of where we're at. So if you have any questions, we'll be here for the rest of the afternoon and enjoy the information. Thanks.
Thank you, Barry. Yeah, unfortunately, we've heard a lot of complaints, obviously, over the last few months as groups have gone through budgeting season. Why is insurance going up so much? It's essentially the number one cost factor in increases in the budget. I've sat in meetings where agents get, chastised, blamed, yelled at, etc. Why aren't you doing a better job? It's not about the agent not doing a good job. It's that they literally have nothing to choose from right now. This is not the market that it was 5 years ago, where we had ample coverage and the relationships were all that mattered. I think everyone right now has the same relationships, which are extremely minimal. So it is not the agent's fault, I will say, right now. The only thing we can hope for is a few quiet years on the storm front to allow the insurance companies to regroup. Hopefully we'll find some relief in the next couple of years, but I agree with Barry. I don't think we should expect a miracle next year and perhaps not even the year after. So if you're getting by with 50% increases or less, consider yourself lucky these days, it seems, as we're still seeing triple-digit % increases regularly, not even necessarily for high-risk communities either. So everyone's doing the best they can. So please, understand that most of our hands are tied, and don't beat up the manager or the agent. They are trying their best, and unfortunately, they're in a tough spot as well. So that's insurance. It does obviously tie into the primary conversation here today, particularly from a cost factor. So with respect to the costs that I'm referring to, that's primarily the new reports that 3-story and higher condos and co-ops are required to do. And that's where we're going to start, so to make sure that we have an understanding of those obligations, because the timeline is coming due soon for these reports. And the reports I'm referring to are, first, the Structural Integrity Reserve Study, oftentimes referred to as the SIRS report. That is a new mandatory reserve study that all 3-story condos and co-ops will have to perform in this state by the end of next year, by December 31st, 2024. Now, this is applicable to all condominiums of that height, regardless of age. The reason I mention that is because the other side of the requirement, the milestone inspection by the engineer, is tied to the age of the building. Now, when the law first passed a year ago with SB 4, that was, there was a differentiation between age requirement with those condos that were 3 miles or less from the coastline having a 25-year marker, and those 3 miles or further from the coastline having a 30-year marker. That has been eliminated in the statutory changes this year with SB 154. Now all condos, regardless of location, are at the 30-year mark, unless the local building department decides that you need to have yours done sooner. You should all expect to get a letter from the local building department indicating when your milestone inspection is due. They will then give you 180 days from the date of their letter for you to get it complete. The local building department is going to get a copy of your milestone report. That will be on file with them. They will also then ensure compliance with that report. And compliance means that within 1 year of receiving that report, you will need to commence any reconstruction or remediation of your building as identified in the engineer's sealed report. So Some of you may find that your local building jurisdiction decides that 30 years is too long, depending on the nature of your building or the location relative to the salt water, which is the primary corrosive effect that we're worried about here. Carter will comment more on that when he takes the mic. But know that it's coming. So you can at least start with a baseline of tracking from 30 years from the certificate of occupancy issued on your building. For those of you who were already 30 years old as of 2 years ago when the initial law passed, your deadline is the end of next year, 12/31/24, same as the CSRS report. So many of you in the room are probably having to do both of them simultaneously. We'll start with the CSRS report because that's the one that I know all of you will have to do by the end of next year and is going to have immediate ramifications for your budgets as early as next year. I don't know that many people have received those reports back yet. How many, by show of hands, have actually received a CSRS report back thus far? Okay, so a few. Now, hopefully we all did this right, but if not, it's okay. We'll get it fixed. But once you have the CSRS report in hand, what's important to note is that you now have your funding requirement for those accounts. And just to summarize briefly, and we're going to have Matt talk more on the CSRS component in a second, but here are the categories that go into the CSRS. And by the way, the handout that I have at each of your desks is our legislative update from this year. This contains the salient points about milestone and CSRS, as well as some other statutory changes affecting condos and HOAs. So you can take this back and read at your leisure, but if you want to follow along, this is then on the bottom of page 2. So the CSRS is going to cover the roof, the structure, which encompasses load-bearing walls, primary structural members, primary structural systems, fireproofing and fire protection systems, plumbing, electrical, waterproofing and exterior paint, windows and doors, if your association is responsible for their replacement. That is a declaration question that you're going to need to get an opinion letter from your attorney in order to give to the CSRS provider so they know whether to include windows and doors in their report or not. Not all condos are responsible for the replacement of windows and doors. Oftentimes that is a homeowner responsibility, in which case you will not have to reserve for those items. And then of course the catch-all category, any item that has an expected replacement cost in excess of $10,000 and affects the integrity of any of those items that I just mentioned. Now, this can be, and we'll have Matt and Carter comment on this as well. Both are preparing CSRS reports at the present time, but it is up to the engineer or the reserve specialist to make a determination as to whether any other components within your community are considered structural in nature. A great example would be a seawall. If your seawall sits 20 feet from your building and theoretically prevents your building from going into the bay, it is a structural component? Yes. Okay. So, why is this important? Rewind time a couple of years ago, Florida statute for condominiums has always said that items with an expected replacement cost in excess of $10,000 are mandatory reserves for condominiums. So that included specifically roof, painting, paving, and then any other item with the $10,000 or more replacement cost. That would have included your seawall. That would have included other components that are now listed here. However, it is possible, as many condominiums did, that you also took advantage of the statute which allowed you to waive the full funding of those reserves throughout the years. So it is certainly the case in some condominiums that we may have a 30 or 40-year-old seawall with very little money in the account to replace that item. Those are very expensive replacements. So what's going to happen with the CSRS reports when they come due, as I mentioned before, is that starting in the year 2025, when you are sitting down that fall making the budget for 2026, you are going to be required to fully fund all of the CSRS items. If that's $1 million seawall with 5 years of useful life left, you are going to have to raise a lot of money in a relatively short period of time. If you have millions of dollars worth of roofs in your community that you have waived funding on for many years, and you are down to a couple of years of useful life, you are going to have to raise a lot of money in a relatively short period of time. You essentially have one budget cycle left next year to choose your level of funding for these SERS accounts. You can certainly start fully funding them next year if you choose. That is a board decision. Or you still have the option to waive SERS accounts, this year and next year, but these are the last 2 years that you will have the opportunity to waive those particular funding requirements. You are going to have to make strategic decisions in concert with the professionals and in conversation with your membership as to how your communities are going to start funding some very expensive projects very soon. This is why we're trying to put the knowledge out as best as we can to as many people as we can, because you inevitably are going to have residents in your community, and I'm going to ask Phil and Annie to comment on this, whose financial wherewithal may not be in alignment with these funding requirements. And we are also going to have to deal with the human factor of that as well. The board's job is not enviable in this environment right now, but I will stress again that it is absolutely critical that we have responsible, strong board members to get our state through the next few years. It's not going to be fun. It's not going to be pretty, but we will survive if we do it right. Come 2025, though, the reserve waiver is at an end. Now, you will still be able to waive funding for your other non-SERS accounts, so the paving, perhaps the pool, the tennis court, the clubhouse, the gate, the irrigation, the other items on your property that theoretically should have been reserving for all these years but have the right to waive, you will continue to have the right to waive. However, the standard for waiving has now gone up. The state has told us, essentially, by inference, that they are no longer a big fan of associations waiving the funding of their reserves, and for good reason. So, in the past, the standard was a majority of a quorum of the membership. So, taking a 100-unit condo for easy math, typically the association bylaws call for a majority to constitute a quorum. That would be 51 votes in order to have a valid membership meeting in order to waive funding of reserves, and you only needed a majority of those respondents, so theoretically 26 at a minimum, in order to waive funding. Now, the standard is a vote of the total number of units, so we need a minimum of 51 votes to waive funding of reserves. And we know how difficult it can be to get quorum and to get votes. That is not relevant to this equation. So your jobs are to get votes to waive if that's in the best interest of the community. Otherwise, the board is going to have to adopt a fully funded budget, like it or not, perhaps. So this is one of the changes in the law this year that actually will affect everyone, 1- and 2-story condos included. Your waiver requirement or your transfer requirement, if you're seeking to use reserves for an insurance premium payment, for example, the board does not just get to do that. You cannot touch the reserves for any unintended purpose without consent of your membership. There is no such thing as borrowing from your reserves. If you need your reserve money, you take a vote of your membership by a quorum, getting a quorum of the membership present and getting a majority of the total members to agree with the board's decision to waive or transfer reserve funding. And the state is going to be taking this very seriously. So we need to make sure that we're understanding how protected those reserves are and how we can potentially tap them. One best practice option that a lot of communities use is to put a question on the annual meeting proxy, which is the one that, if we have a fighting chance of getting people to actually open the envelope and return it to us, it's typically the annual meeting. If you want to have a question on your annual meeting proxy to give advanced opportunity for the board to use reserves in an emergency basis, put it on a proxy, get the vote. That you can then use later in the year should you have the need to transfer reserves, for example, for an insurance premium. I think that's an opportunity that a lot of associations would probably benefit from, so they're not scrambling, trying to raise capital to pay an insurance bill that's due in 30 days, for example. So these are the kind of strategy discussions you need to have with your property manager and your association general counsel attorney to make sure that the board is fully apprised of its options so that you can make the best decisions for your community. There's not a one-size-fits-all answer, but there are typically best practices that will help you navigate this maze in an effective manner. So with that, let me turn the mic over to Matt Kuisle from Reserve Advisors. Oh, we'll take a question, and that's fine as well, actually. Yes, ma'am.
Yeah, did I understand you to say that if the board comes out with coffee and says that you want to use the funds from different retailers to pay for insurance, that once that's approved, then next year you do not have to get that
Annual
voted?
basis, I would say. The question was if we take that vote to give the board advanced approval to use reserve funds to pay an insurance premium if necessary, I would tell you to do, you would have to do that on an annual basis. That is not a standing order that would last in perpetuity. You would do that on an annual basis. Matt? Yes, ma'am. No, it's okay, please.
So 2 stories and below still have to fully fund?
No, 2 stories and below, your requirement stays the same. Painting, paving, and roofing are your mandatory reserve categories that must be fully funded unless you take the membership vote and get the majority approval to partial fund. Painting, paving, roofing, and any item with an expected replacement cost in excess of $10,000. That will be unique to your community and could be any number of things. So for the 1 and 2 stories, the only thing that changes for you is that it is more difficult to waive the full funding of the reserves or to transfer the reserves. Everything else remains the same. Matt, tell us about the SIRS and what you're finding so far.
Sure, thanks, Dan. We've done a little over 100 structural integrity reserve studies so far. It was a new thing, so we had to kind of learn what to do. The requirements changed a bit in June of this year. So we've modified it and kind of we're pivoting as we go. But what we've seen so far is a lot of the buildings that we've worked with have been buildings that we've been working with for years and years. And those communities are not in really rough shape. They're actually, from a reserve standpoint, on a healthy path. The one thing that's impacting everyone in addition to insurance is inflation. So even for a community that was right on track with all of their reserve needs, the fact that roofing has increased 30, 40, 50% since a year or 2 ago is hitting everyone. So everyone's seeing a requirement to increase the reserves. But we do have communities that have been playing very conservatively and have sufficient reserves to where the SIRS is not a significant increase. On the other hand, there are buildings, like you mentioned, that years and years and years they've waived. They've partially funded. They've told themselves that we can't afford to fully fund the reserves. They've told themselves, I'm not going to be here when that project's needed, so I'm not going to, pitch in for the next guy to get a new roof. And that mentality absolutely has to change, and is changing in those communities. And those communities that said that are in worse shape, and they are going to have a little bit more of a painful process to get from that to the fully funded, because not only do they have to now increase to a higher funding level, which other communities have been at, but they have to make up for the lack of dollars, and in a lot of cases, the deferred maintenance that's been going on in the building for many, many years. Boards can be in a really, really impossible situation. We did a lot of case studies right after the task forces, right after the collapse, and the story of what that building went through, knowing that they had millions of dollars of structural repairs to do, was heartbreaking. There were board members there that were trying to do everything they could to secure financing, to pass a special assessment, and the membership simply said, no, we don't want to pay for it. And so that can never happen again, and that's where we're at. And so with the SIRS, there's a lot of unanswered detailed questions that thankfully SB 154, which was passed in June of this year, clarified a number of them. We're hoping to see a few more clarifications in the session this year, but what they did, and there's kind of this philosophy, right? Before we've been able to waive everything, every community could go and say we want 0 reserves, let the next guy pay for it. And then there was the instant reaction was, no, let's stop doing that. We have to reserve for everything. Every board's going to have to take care of these items. These are not discretionary items that are needed. And just like any good politicians, they compromise, they kind of smash 2 things together. But in the end, they said we're going to reserve for some things. We're going to have to reserve for some things. And they chose the structural things, the things that would impact the viability of the building. And they said other things are cosmetic and not really needed. And that's what Dan's mentioning with the non-structural items that we waive. However, when we do the reserve studies, how many of us have a building with an elevator in it? Is that an important aspect to your building? I mean, and I know our elevator consultants are in the back. They can answer this. Is it less than $10,000 to modernize an elevator?
Yeah, for sure.
So when we have that situation, there's still going to be really important things to weigh, but you have that lenient, that leeway right now, and a lot of communities are looking at the ones that have a reserve are saying, okay, some of these items we can continue to kick the can on, but these are the items, and it's just a way to try to get from point A to point B, because there's an absolute recognition. There's been a number of news stories about fees that are going up. There will be many more stories about people on fixed incomes that can no longer afford to live in their condos. To this point, the legislature has said, move. They've been pretty firm on that, and I don't anticipate that to necessarily change. But we'll see what happens with the next legislative session. There's also a lot of things coming down with regard to board transparency. And so that's one thing I think we all need to take away from this, is that the state and our job as fiduciaries is to be transparent with what's happening. It is not your fault as a board member that the insurance premiums are going so high. It is not your fault that inflation is occurring. It's not your fault that these new laws are in place. These are circumstances that we need to be clear on, but it's not your problem. It's not you personally that made this happen. I know it's hard to tell your neighbors that it's going to cost more to live in the building. It's very hard to have those conversations with people on fixed incomes that have been paying a certain amount, and now it's going to go up a lot. And those are very difficult conversations to have, but it's critical to just be transparent about what that is. And I know that's what the realtors are hoping to do, and there's a lot of changes in that aspect of the work.
And if you could get Phillip and Annie to start
Yeah.
commenting on that financial impact component, what you're seeing in budgets, what you're seeing in sales, please help us understand.
So the question is, what's the financial impact to the budgets for these reserve studies? And there's a big conversation on the reserves for, okay, how am I going to fund this? Am I going to have to fund each line item? Take over here in the non-structural or in a different bucket. My understanding right now is we can pull those funds into that structural bucket. Is that no idea? But that's where I am directing my boards right now to think about taking the money that you've always had line items and pull it, because you don't have to raise your fees as much for others for this part. Many of my boards are not in favor of pool because they're always afraid that the next board is going to come in and be irresponsible with those monies, and they'll use them to redesign the lobby or something else. So now that we have specific guidelines as to what you can do with this money, they feel more comfortable. We're taking those votes, and hopefully the owners will agree that, okay, this is an option. I have several owners who have called me over the last year or two and said, we're putting our house on the market. It's not that we can't afford to live here any longer. We choose to use our money for things that we want to do. The insurance rates are going crazy. The one thing none of us have talked about is, hey, if you have a roof that's 15 years old, you're getting a new roof soon, if not within the next 3 years. If you put a coating on your building within the last 5 years, which several of my properties did, the roof coatings were big things. They were a lot cheaper. Citizens doesn't care. It's gone. It's not valid. We want a new roof. So if you spend $50,000, as one of my properties did in 2021, against my advice, they're now spending $250,000 this year to get a new roof. Are they happy? No. They're going to go to Tallahassee and camp out in front of Citizens for a week and force Citizens to change their mind. And I'm like, that's fine. Can we start funding $200,000 and at least get a roof estimate out here to tell you what it's going to cost, because you're going to lose. So as a property manager, whenever I send out a budget, it was always, here's what's happening with your budget. This is why things are so bad. There's some things we can do. When 75% of your budget is reserves, insurance, utilities, the only people you can cut are your service people. You can cut your lawn guy, you can cut your pool guy, you can cut your property manager. The savings is nickels and dimes, and we need to come up with $100 bills. So have conversations with your owners, especially those that you know are on a tight income. And, see what can be done. And hopefully Annie will have some help for those people.
So I think it's important, my understanding is that when Champlain Towers fell, they had not too long before spent more than $1 million redoing hallways in the lobby. So the building that collapsed was gorgeous. The interior was wonderful, great sense of arrival. And as a real estate broker, it's important that things look good. However, as a human being, right, and having concern and a board member, it's much more important that the people that live there are safe. And so unfortunately, the government had to choose to regulate us because we don't have enough sense to protect ourselves. We'd rather have a beautiful lobby, case in point, Champlain Towers, than we would have spent the money necessary to get the work done. Now, they were working on getting financing to be able to do the necessary projects. It wasn't that they were unaware, it was that they had ignored them sufficiently long enough that they were past the point of being able to pay me. And I know there were other things that we don't need to go through, like they used structural things, what do you call them, as planters?
Yeah.
So there were structural members, I don't know what the word for them is.
Yeah, column beams, but yeah, it's not a good idea.
And they were there to support it, they thought, well, they're ugly, let's put dirt and palm trees in them. Well, palm trees grow, so what was maybe attractive in dirt, it holds water, right? So there were a lot of things that happened there that were different, but the issue is that there are a lot of people who unfortunately are being squeezed very much, right? The HOA that I manage has had a 221% increase in the insurance fees between 22 and what we're going to budget for 24. So that's tough, right? But it is a transient accommodation. It's not a first home for anyone, so they're able to afford it. Last night I was showing a property and the lady said, I'm moving. I'm not going to pay if I got my new budget in and I'm not going to pay for that. Well, she has the opportunity to be able to sell. Some people are stuck in over 55 communities. Some people have properties that with the milestone inspection will no longer be warrantable, so it's more difficult to get financing. And I just think as homeowners, it's really important to be aware of what's going on. I cannot believe that people still don't attend the board meetings, given the volatile situation that they're in. And you would think that there's enough information out there, so I would say that's the first thing that's important, is to get participation and awareness. And it makes it better on the board members that tell people this is what you're going to have to pay in order to be legal and safe, right? But for those people who can't, there are reverse mortgages that are out there for individuals that don't have the financial wherewithal to be able to meet the expenses. They're expensive, but if you're 80 and you don't owe anything on your home and you can't afford to live there, 10% of people that are octogenarians and past die very quickly after moving. I know, because I used to be a nursing home administrator, right? So that's not a bad alternative. It sounds awful, right? I hate those ads on the television, right? They sound predatory. They're not anymore. It's how some people will be able to stay and age in place in their home. So it's important, and one of the things we do is not just sell real estate, we help people to find answers to solutions. And, that's what we do. We try to help people, then eventually, when we become a trusted advisor, they'll trust us to sell their home in time as well. So it's important to know that that's something that is available. And it's important to be involved, right? And it's also important to know that your board has to get these inspections done. If they don't, you're not going to be able to sell your home, period. Right? They've got to have that. It has to be transparent. They have to post a copy of it in the lobby, right, of the milestone inspection. And so there's no hiding it. It's on the disclosures. And that's what it needs to be. It needs to be transparent. That's the only way that people can feel safe. And that if your home is not your safe haven, you have a really big problem.
Are you seeing buyers doing more due diligence and asking questions now related to building safety or budget increases and actually investigating the homes they're buying more so than in the past?
Well, they are, and the condo writers, the Florida Realtors Organization and the Florida Association and the bar They actually include disclosures that say, if there's a milestone inspection that is available, it must be, the summary of the milestone inspection must be provided. And if the service has been completed, that needs to be provided by closing. Unfortunately, it doesn't talk about what happens if it isn't provided, right? It has to be provided, I said completed. If it's been completed, it has to be provided to the buyer. So it's more important than ever for buyers to be well represented and to understand that even though that contract says that they have to be provided a copy of it, it doesn't say what the consequences are if that doesn't happen. So as opposed to your condominium documents, which there's a right of rescission built into the contract, that does not happen and has to be written in at this point in time in your contract to protect you, because if they don't provide it, now you have a fine. You'll probably win, but you'll spend money at that point in time. Yes, your hard-earned dollars on something that if you had known about in advance, you could have taken. So it's important to be smart about it and understand what's going on.
Let's get into the milestone, and I'm gonna have Carter take the mic in a minute here, but so we've talked a lot about the SERS, which is the budgetary tool that you will use to help fund the long-term replacement or rehabilitation of your structural components. The other half of the inspection requirement is the milestone inspection. Now, this is a visual inspection of the building by the engineer to determine whether there are any immediate needs that must be addressed in order to ensure the safety and security of the building. So what the milestone inspection is looking for is signs of substantial structural deterioration, which Carter will comment on. In phase one of the milestone inspection, the engineering firm will do the visual inspection, produce the report, and identify any items that are in immediate need, and also provide, I believe, a maintenance plan for the building moving forward as well to help us understand what we'll have to do in a more long-term basis as well. If the engineer finds that there are signs of potentially troubling conditions within your building, they are going to fail you on phase one, and they will require you to go to phase two, which involves some invasive testing within the building. So they will start peeling the onion layers back in order to get a better look at what's actually happening behind the paint and the stucco to ensure that we don't have hidden dangers that will eventually manifest in an unsafe condition. Once, as Annie indicated, once the milestone inspection is completed and it is sealed by the engineer, they're going to produce both the long form copy, which you will keep in your records, and also a summary copy that will be distributed to all members and posted conspicuously on the property and posted on the association's website if you're 150 or more units and required to keep a website by statute. This will also be provided to all incoming buyers as well as part of the sales disclosure. So, and a copy will be provided to the local building department as well. So this is going to be a fully transparent report regarding the health of your building. With that, I'm going to turn it over to Carter to talk about the milestone inspection philosophy that Ray Engineering uses and some of the things that they've encountered as they have started inspecting some of our local buildings.
What? Thanks, John. All right, y'all. Talking about the milestone, so we can break it up into phase one, phase two. The really important thing with phase one, that's Dan touched on, is it's the visual inspection. So this is why, and I really want to emphasize, especially with phase one, phase two, why it's really important to go with a structural engineering firm who's experienced doing this, because that's going to help make this process very efficient, prevent additional unnecessary openings in phase two, because you'll have a structural engineers, who does this all the time. And so pick up on patterns, understand why things are happening, especially someone, a structural firm that has design experience as well, because it can really inform the inspection portion. So phase one, that's going to be the visual inspection, where we're looking for significant signs of structural failure, distress, or potential sources of that. The thing I want to emphasize with what's included in milestone, because you have it really nicely broken out in the SERS, all the different line items. The milestone is in the same spirit as the SERS, so we're really looking at pretty much the same things, and Dave touched on as well. he used seawall as a perfect example. We'll have an engineer where we'll run calculations to determine whether, the seawall can be impacting the foundation of the building. You have it to where you have a parking lot nearby right up against the building that has a large hole, and no water's getting underneath, those sort of things. So that's how a milestone can encompass anything that impacts the structural aspects of the building. The really big thing boards need to try to change the way they think is that the main focus is as long as the building envelope is maintained properly, that's your painting, that's your ceiling, that's your exteriors, windows, roof, as long as that's maintained properly, that's how you can avoid the structural issues most of the time. So that's where there's a big emphasis on boards needing to be more aggressive, painting and restoring their exteriors, especially breezeways. That's one big thing. As far as my experience, what I've been seeing a lot of the time is it's almost like the open breezeways are sort of an afterthought. Everybody thinks, taking care of the roofs, taking care of the exteriors. But the problem is that most of the time those breezeways provide egress for residents. And that's pretty much one of the most important aspects when people are walking into their homes, going upstairs, going through their breezeways. So if I go back, phase one, we summarize, especially our reports. What we do is we like to keep it simple, not complicated. So we break out each of the items, and then we go through and show typical examples of each of the issues that we're seeing. And then we'll have an explanation as to why, hey, this is why this is happening. And then we'll have in there scope of work of typical repairs, what needs to be done. Of course, if we're seeing significant structural issues, or we're seeing signs that there are some. So the perfect example, a lot of these concrete structures have stucco on them. If we're seeing significant water damage on the stucco, and we're seeing cracks, we don't have X-ray vision, so we don't know if those same cracks, those same issues are happening behind the stucco. So typically, as we were talking about the failing of phase one, the best way I can describe it, it's not so much your building has failed phase one inspection, but it's mostly, think of phase two as what you can't see, or if there, of course, is significant structural issues that you're able to visually see. That's what would take you to phase two. So best case scenario is that phase two is, hey, we have a few of these areas along the exterior where we're seeing significant spalling of the stucco, or significant spalling of the exterior, or let's say we're seeing corrosion on steel walkways, but there's a soffit. We need to see a closer look. Best case scenario is we open it up, and let's say it's a minor repair. It doesn't involve a significant process. That's best case scenario. Worst case scenario, which I'm seeing both, is we open it up, the steel framing is significantly corroded, the connections are failing, and then that needs to be shored up. And after the whole phase one, phase two process, that's where we move on to a structural design for repair, bidding it out to contractors, having that restoration process. The benefit of what the legislation's done is they have it to whoever's doing your phase one inspection is pretty much your same engineer the whole way throughout. The benefit of that is, one, it ensures it's efficient. As I'm sure anyone who's retained an engineering firm to do something 2-3 years ago and never got done, and you want to bring another one in, 9 times out of 10, that engineer will say, hey, I got to do everything from, starting from scratch because we're going to be signing off on it, it's liability. So the benefit is the fact that you have the same engineering firm working throughout the whole process. So that ensures it's efficient, that ensures that the engineer who's with you, because there's going to be so much interaction between that engineer and the board, there's full transparency, and they can walk you through that entire process because they're going to be involved in that process. The worst thing is when you get a document saying there's significant structural issues, then, but boards feel like they're just left with that. So the good thing is that with this process, at least, that you have a structural engineering expert that's with you the entire process the whole way and lets you know roadblocks that are going to happen and be transparent the entire process. And that's why, as I emphasize, it's important to have a structural engineer who's experienced doing this, because the more they see, the more they're able to tell you, hey, I've seen these sort of issues. This is typically how it goes, especially when it comes to permitting, engineering repairs, because there's a million ways to skin a cat. So the thing is that when you involve an engineer who's typically done a lot of these stuff, because even though a lot of these condominium buildings look different, you typically have some of the same issues that happen at most of them. Perfect example was I brought up the breezeways. The best way I want to emphasize as far as the building you're in, how concerned you need to be. We can break it down to this. Wood frame buildings, reinforced concrete buildings, steel buildings. Of course, we're talking 3 stories up, wood frame buildings are very common because, of course, the wind forces that are experienced. And the issue that you have with wood is, of course, let's say stucco your exterior, water damage, water infiltration. That's the big thing with the milestone inspection. It's almost always having to do with water infiltration issues. That's going to impact the wood the fastest out of everything. When you deal with steel, the big thing to think of with steel, especially dealing with exposed breezeways, exposed stairs, you need to be, the closer you are to the coast, when you're bringing it up before the seawater, you need to be extra aggressive when it comes to taking care of all the steel items, because what ends up happening, a lot of people, they'll see corrosion on steel, rust on the steel, but the important thing is at the connection. So you can have it with the whole member's fine, but of course, water's going to edge towards the building. That's where it's connected into. You can have it where 99% of the steel beam looks fine, but the connections are failing. And a lot of people miss that. That's where you can end up having failures. I'd say probably about a quarter of the milestone inspections I do, we end up having to call to have emergency shoring put in. The benefit of that is to make sure that the residents still have egress into the areas. We don't just block down stairs or breezeways, especially when you have residents going in. So the benefit is that having an engineer involved means you're going about it in the best way to make sure, one, the money goes the farthest, but two, you're not having to worry about opening yourself up on the building because you have a structural engineer for you the entire time. Another benefit to it is insurance companies. A lot of the time, sometimes the state will, especially with the new updated legislation, the state will tell the local, the local municipality. You'll have insurance. They would provide letters to the insurance company, letting them know what's happening, especially to homeowners. Because of course, as soon as there's any sort of large work done, every single homeowner, freaks out and starts contacting the HOA. So it's always good to have an expert to where you can say, expert has said this. And in my experience with a lot of the condominiums I work with, we end up drafting letters that the HOA can send to the residents, that sort of thing. So the big important aspect of this is wherever you have retaining, transparency and communication is like the biggest thing. Because what ends up happening is you don't have it to where it's a scary process. You don't know what's happening because it frustrates everybody. So the goal is with Ray Engineering, what we do is we make sure, as I said, the board, we're fully transparent with what the whole process is. We help them along the entire process. I want to touch a little bit about phase two. So as I pointed out, phase two is the best way to describe it is things you can't see, or of course, you have significant structural problems. The idea with it is, and this is why it's very important to go with an experienced structural firm, is the idea behind it is, as a structural engineer, you're usually seeing typical conditions throughout the whole property. So let's say you're seeing the same sort of crack in the same position at every single floor in the column. It's not necessary to open up every single one of those. You just need to open up one to get a better idea of what's going on. So that's why it's important when you phase two is on the engineer. One, we need to make sure we expose enough to feel, all right, liability-wise, we're okay signing off on this. We've seen enough. But we want to make sure we're efficient in the sense that we don't open up a million holes. And, no one likes that when their building has a million holes. So the goal is once those are opened up, they're evaluated quickly. We're on site right either during or right after, so that way we can make our evaluation, cover up those areas, and of course, we end up finding significant structural findings. That'll be handled after the phase two, where there'll be engineering, design, repairs, and drawings. And as I said, the big benefit of having a structural engineer take you from the beginning to the end is they'll be involved in the monitoring process to make sure at the end of this, all this money that's being spent, it was spent correctly and it's been done correctly because we have an engineer signing off on it at the end of the day. So,
Carter, speaking of the million, hopefully not $1 million question, of course, and for Matt too. Average unit cost or per unit, if you can ballpark, and time of completion for the month, and then add on the service, because I'm sure everyone wants to know.
So as far as the average cost you're retaining somebody for, so typically our average cost that we've at least been seeing in the market is somewhere between we'll say like $70 to $100 a unit. And this depends on the size of the unit. I mean, the size of the building, of course. If you start dealing with small buildings, with low number of units, of course, it's kind of a minimum. But between $70 to $100 a unit, I'd say for the SERS. And then for the milestone, typically milestones done with the SERS, 9 times out of 10. Typically, we're looking at somewhere between, say, 130 to maybe 160, something along those lines.
And how long from beginning to end to get the milestone portion completed?
So I would say between it getting approved, we're typically out on site somewhere between, I'd say, 2 to 4 weeks maximum. And then the turnaround time, typically we put in our proposals 12-week turnaround just to give enough time. But I want to emphasize during this entire process, we're communicating this entire time. As in, if we see issues that are coming up that we know, and this happens almost every time I go out on site, if I go out there and I see, all right, we have an issue, this is going to go to phase 2, we're immediately in contact with the board of property manager saying, all right, here are your next steps, here's exactly who we're going to have involved. So instead of the board and the property manager sitting around waiting for that one report, y'all aren't just sitting around, we're having everything in process. So that way everybody can see, what type of testing is going to be involved, that sort of thing. And as I said, full transparency during the entire process. So we can pretty much give you an idea of, here's exactly what you're going to be dealing with, what's going to be in the phase 1, what's going to be included in the phase 2, what's going to need engineering repairs. So as I said, I know 12 weeks may sound, let's say, side proposal to finish, it might sound like a little while, but the benefit is we're communicating with you the entire time to make sure there's no one's just sitting around. There's something that's always being done. Then when it comes to phase 2, that's really dependent on what we find. If you're talking about opening a few number of areas in the exterior, I mean, that's a really quick process. That's just confirming those sort of issues. If it's something that includes, significant structural repair, phase 2, depending on the complexity of it, phase 2 might just be engineer design drawings are required because the repairs are so extensive or significant enough issue that this is something that can't just be put in a report. So that's typically around the turnaround that we're dealing with. Yep.
Matt, would you like to comment from your perspective?
No. I really don't like to discuss price and settings like this because it's really specific to the building that you have, the facilities that you have, the amenities that you have. I mean, you could say our average SERS is $5,000 to $10,000, but that's not going to mean anything to your building. So don't go and tell your membership it's going to be $5,000 for the SERS. It's going to depend on your building. The other considerations to think about with this cost is what does it include? Because I know there's some firms, I'm not sure if Ray includes everything in the building or not. So like we talked about the elevators and other things would be generally we're looking at both of those sides of it. So some providers are saying you need a traditional reserve study and a SERS. I think that our firm is taking the approach like we just want to do one study because the traditional items are kind of crossing over to the SERS, and that allows us to determine if an item could go into one category or the other. And it also allows us to examine where the funding plan needs to go. So a big part of the SERS and any reserve study is the financial output and determining what components need funds where. The only way to really determine that is to look at everything and say, okay, we have a major elevator project moving up, so we want to leave some money in there, or it's all SERS items, so we want to take your existing reserves and put them into the SERS items. So, and then the other thing is follow-on. So some firms will charge by the hour for follow-up meetings, follow-up discussions. So just be aware of those things when you start to look at bids and your proposals. And you, Phillip, mentioned something about pooling the reserves. I absolutely think that's going to still be allowed to be done, but it's generally 2 pools, like we talked about. And then I think there will be, with each of those pools, you kind of have to look at cash flow. And I think majority of associations, it's now been 21 years this month since the state of Florida allowed pooling of reserves. And it's been a very slow migration. I think we're finally at the point where 70% or more associations that we work with are using pooled reserves. And I think this further restriction of reserves will hopefully get the other 30%ers to realize we don't need to have a specific account for each item that you have, a specific balance for each item. look at categories, give yourself as a board that flexibility. And it's a much, much lower funding requirement when you're looking at pooled reserves versus line item straight line reserves.
One comment, just on reserves, just keep in mind with pool, if you are seeking to go from component to pool, the board can make the decision to start the pooled funds, but the membership must give you their vote to transfer the funds from the component accounts into the pool. Otherwise, you're only capturing the ongoing reserve contributions from your budget into the pool. And if you can never get that majority vote to move the components into the pool, that means that once the replacement is required, you're going to expend all the funds in the component account, then go to the pool to make up the balance. So we can't just by board action only take all the reserves and dump them into the pool just because the board decides they'd like to start pooling. We have to remember to take that vote. Also, as a reminder, Matt and Carter comment on this quickly as well. Then I'd like to hear final comments from Phillip and Annie on anything that we discussed, and then we'll take some questions from the crowd. But we're now approaching the 1 year mark on deadline for completion of SERS and in many cases, completion of milestone. What is availability looking like, and what can the folks in the room expect if they have not started yet to even explore or bid out these projects?
And that was the second half of your question before that I didn't answer, so thank you for the reminder there. No, it is, we absolutely, I don't think have enough engineers and reserve specialists to get every community in the state done. There's probably, by anybody's estimate, 20,000 plus or minus associations that are subject to these new requirements. And I don't see any way, there's a big portion of them that are still waiting and hoping that the law is going to change yet this year, but it's not going away. We're working with them right now. As long as you have a good faith contract, I think, signed for the milestone inspection by the end of next year, even if the work doesn't get done next year, you're still in compliance. There's not a similar requirement for the SERS. At least the SERS has to be done by the end of next year. We're already booking into April and May of next year, so within a few months, 2024, we're going to be full. So we are working. We've got some positive response from the legislature that they'll put a new requirement in this year that would say, yes, as long as you sign your contract by the end of the year, you can do the surge early next year. Because for most, the budget implications aren't until early. But do not wait. There's really no benefit to waiting, and it's really probably only going to get more expensive and more difficult to find good people to do it as we get closer to those deadlines.
Carter, just comment on availability, please.
Yeah, so availability right now, as I said, right now, if we get a request, so we get an approved proposal, right now we can be out within 2 to 4 weeks. And like I said, that 12 weeks we put on from sign of proposal, that's just worst case right now. Typically, we've been able to turn around, like I said, somewhere between like 8 to 10 weeks, I'd say, maximum, depending on how big it is. It's a small property, of course, turnaround time's much quicker. And depending on how good a condition it is. Of course, we're talking about a really good condition property. I mean, you could have a milestone report turn around in a couple weeks. So really comes down to the condition of it and everything. But it seems emphasizing next year is right now. This is all the proactive boards. This is all the boards that are at least being forced right now. What's going to happen is, midway next year, you're just going to get the engineers and reserve study specialists are just going to get a tsunami. And so what you want to do is at least get on the books, get on schedule as soon as you can, because this is the whole process. So once the milestone phase 1 is done, then you go to phase 2, then you get the phase 2 issues, and then depending on what you find, you have to get started within a year. So I know it feels like you're spending a lot of money on having an initial study done, but what I can really emphasize is if you pay for that study and have that done, you'll have all the knowns. And so I know it's people don't want to rip the Band-Aid off, but it's much better to have it to where you spend the money and you have all the knowns and you know what's coming in the next 5 years than put your head in the sand and then you're being forced to get it done as quickly as possible. Find whoever can do it. Of course, the good people are probably going to be taken. So the straggler, engineers or anybody else like that, you can find that can turn around quickly. I mean, hopefully you can. But it's going to go from what's already a stressful, unhappy experience to even more stressful and even more unhappy because now you're under the gun for getting into the deadline. So Yeah, just want to emphasize, get done as soon as you can, just because, yeah.
Well, and unfortunately, to follow up on that as well, selection of your professionals is going to be of paramount importance because you are bound to the findings of that study. There is no jurisdiction for the board to disagree with or act in contrary to the SIRS findings or the milestone findings. So engaging the right professionals with the right philosophy, the right staff to get it done, and the right work product is going to be paramount. You are going to have to follow that study, or else you're going to be doubling your expenses to go out and find a replacement company to give you a report that you feel more comfortable relying on. This is not discretionary at this point at all. The other note, just want to reiterate what Carter had said, because the next rush that comes after the engineers and the reserve specialists will be the reconstruction specialist. You will have 1 year to commence, not to finish, but to commence your repairs as indicated on the milestone report. So now is also the time to start forming relationships with the general contractors, whether it's the reconstruction experts of the world and their like, in order to make sure that you are on the docket to get your buildings actually fixed once these reports start coming in. So I'll remind you of that as well. Let's get final comments from Phillip and Annie as well on anything else, just practical in nature, because these are the boots on the ground folks that are working with you day to day to help facilitate all of this stuff and help fund all these things. Phillip, last thoughts.
I just want to reiterate, don't go with the cheapest vendor that's out there. I have a property, they picked a vendor to do their studies. We provided our historical reserve numbers for them. The reserve study came back and said our numbers were right. And I looked and said, there's no way our numbers are right because we're not experts. But they were told they didn't have to do any more increases. Everything was fine. I have an associate I work with. He got a call from a client. They have to go to phase 2 for their engineering study. The firm that did the engineering study doesn't do phase 2. And when they had a new engineer come out and look at it, he said, I'm not seeing what they're seeing, but it's done. And you've got to find someone to fix what's been done. So they went with the cheapest engineer they could find. So when you find your engineer, make sure they are a structural engineer who focus in on condominiums, concrete, stucco, and not someone out there that is just a engineer, say chemical, biological, because I'm not sure the law is clear as to what the requirements of a PE are. And I know I get lots of letters on a weekly basis from engineers that I've never heard of saying, we can do your work. And a little bit of research has brought up red flags to me. So, work with people that you can trust and be sure you vet them and ask the difficult questions about their license, their training, and their experiences, because if you get a bad one, you're just going to cost yourself a lot more money and heartache.
I was selling a property in a community in Tierra Verde, and they had hired someone to do the milestone inspection. And part of the contract was that any deficiencies that were found, that engineering company would get the contract for doing repairs. I don't know if that's typically common or what have you, but the way that the report was written talked about some things being unsafe. It became immediately unwarrantable. It was a disaster. And I think it's important to know, what their experiences have been with other people. We've interviewed a bunch of people and felt really comfortable with what we did. These gentlemen are here because the experts that are here that work in the industry doing these things know that they know what they're talking about and that they're competent. But it is definitely a case of not being the cheapest. The value of those properties, we're not going to have an inventory problem very shortly. Okay? There are going to be plenty of properties. As soon as you see a plethora of condominiums from an individual development coming up, you can almost be certain that they've either the insurance is hurt them if it's an over 55 community, or they've had a bad milestone inspection. In this case, they should have known, because when I saw the report, there was not bits of falling concrete where it's like bubbling. There were missing pieces, big pieces, right? Something that you would have, if I walked in the store once, I was like, wow, that's concerning, you know? And so I think it is very important that you, again, not everybody here is a board member, and most of you aren't property managers. That's the purpose of this event. Attend your board meetings. Read the minutes. Ask questions. It isn't just the board's fault if it goes wrong, right? It's the lack of interest, and it's the apathy. And there's never been a more important time for you as homeowners to be educated and to be involved in the process. Because A, you want to know that your place is safe. B, you want to know that its value is being protected. Because for most people, it's certainly one of their biggest assets that they have. And you know, you get your car tuned, right? You make sure that your tires work. You should also be involved in the governance and the situation that's happening in your home, in your condo.
On that note, practically as well, if they haven't already begun, there's going to be a lot of difficult conversations happening in your boardrooms over the next 6 months to a year. I would just encourage you to invite in the appropriate professionals to help back you, the board, and the property managers up on having these difficult discussions. If there was ever a time to spend money on your attorney to have them present at meetings to actually put the facts out there and help dispel the myth out there, basically trying to campaign, doing all of these things, now's the time. Invite the engineer to come, invite the reserve specialist to come, invite the contractors to come, invite the attorney to come, and have to truly serve you and earn our keep, because this is going to be a difficult period of time. There are going to be a lot of difficult conversations and owners in difficult positions. Let us back you up. You're volunteers. You also have a fiduciary duty to the corporation to act in accordance with the law. You cannot be bullied, swayed, persuaded, and cajoled into not doing these things. There are ramifications and penalties for board members for not completing these tasks. So while you are going to take some heat, you have to do the right thing. We will help you do the right thing. Let's take some comments and questions from the floor. I'll relay them since the mic needs to pick everything up. I know the questions were over here first, but let's go to Denise.
To the engineer, what is the percentage of units you have to go into for a milestone?
Question was, what percentage of units are typically inspected for milestone and or SIRS as well?
Yeah, that's a good question. In the legislation, it says a sampling size. So pretty much what that is, what we've chosen as far as what we feel comfortable with, is 20% of the units. So the idea with it is we're not going in to look at every small crack in the wall, especially if it's 30 years old. Most of the time it's just expansion, thermal expansion, and extraction cracks you get with the building of any age like that, especially if it's near the coast. You know, a lot of wind over the years, a lot of big storms, you end up having small cracks pop up on the interiors. What we're looking for is significant structural concerns through, let's say, common walls. There's load-bearing walls, you have units right up against it, post-tension slabs, that sort of thing. Typically, when we go inside, we're looking for a source of an issue that we're tracking already on the exterior. So, depending on your engineer, with our experience, I would not be concerned that you would have an engineer come into 20% of your units and then start ripping open the walls. That's should not be happening. If anything, it's just used to help inform us of the common structural elements for the entire structure. We're not looking at every partition wall. We're not looking at people's kitchen floors or anything like that. We're focusing on the, as I said, common walls, common shear walls. All shear wall is, it's a fancy word for pretty much a load-bearing wall that takes sideway load, so you don't have seismic here, but in Florida you have wind. So we're really focusing on that, and it's 20 units is pretty much what we go in. And if we do see a concern, as I said, it's usually sourced to something happening on the exterior. So we would, in our best, to the best of our ability, prevent unnecessary openings in people's units to avoid that.
Do you need access for SIRS?
So for the SERS, at least when we do our milestone and SERS, well, also SERS as well, we also have access to the interiors. Because the important thing is when you're looking at SERS, to have the structural engineering know-how to be able to look at these issues to then inform the prices that you're going to have in the SERS. So that's why it's also very important when you can have structural engineers who do the milestones partner with companies who do SERS, and then that way it's effective. So that way we can inform each other. That's really important because you don't want to have it to where both reports seem like separate reports because they were both made in the same spirit. Because of course, the money informs hey, you have enough money to do these repairs, and then the repairs inform the SERS of this is scope of work we're anticipating. This is going to be the cost of pressing issues.
Marion, access?
Yeah, so keep in mind, the CERS is certified, it is only covering items that are the association's responsibility to repair and replace. So the plumbing, the electrical in your units is not something that the CERS is concerned about. We do like to get on the balconies. Balconies are that exterior work that Carter's talking about, that we want to get a representative understanding of the condition and how they're built. Generally 5 to 10% is all we're going to be doing for the CERS.
Next question.
If you're just doing the SERS, no other one, just the SERS, but it's still 20% you have to get in touch.
Matt was saying maybe 5 to 10%.
It's pretty much the company. It says it's sample size, so it's really up to the company to decide the liability of how much they want to get into, or they feel comfortable. We've seen enough of it in this case.
So there will be an access requirement for the SERS typically. So we've heard up here basically 5 to 20%.
5 to 20.
Yeah, a couple of questions on the timing. We have the 30-year milestone, ours is coming up in a few years. And then after past that, there's every 10 years, I believe, if we have the structural engineering study done now, the structure early, in other words, when do we restart the cycle at some other point?
So the question was about the recertification, which in both cases, SERS and milestone is every 10 years. The question was specifically if milestone is not due, say for 5 or 6 more years, but you decide to align these two, or perhaps you have concerns about the building that you'd prefer to get that study done sooner than your statutory deadline, you're welcome to do that, but you start your 10-year clock ticking with the issuance of the engineer's report. So that's going to have to be a board decision based on factors and considerations that are unique to you, and to determine whether it makes sense to do your milestone inspection prior to the 30 years, either for cost savings, considerations to combine them, or because you think you actually have building condition issues. But regardless, it'll be 10 years from the date of issuance. Do we happen to have anyone who lives in buildings that are less than 10 years old on the condo side, 3 stories or higher in the room? Anyone in younger buildings? Well, I ask because you are now in your final window coming up on the 10th year of the certificate of occupancy in those buildings to address any structural concerns with the developer and builder of those buildings. Once you pass the 10-year mark, you have now exceeded the statute of repose for construction defects, meaning anything you have to put into that building, anything you have to fix, even if it was a builder-related design or construction defect, it's all coming out of your pocket. So if you are in a building that is 10 years old or less, the legislature did us no favors this year by lowering the statute of repose from 10 years to 7 years, with the exception for those that would have an active claim. You'll have until July of next year to file, but very soon we are going to be down to the 7-year statute, and even if there is significant problems with your buildings, we will no longer be able to go back to the developer and builder after such time. So if you are in a younger building and you perceive issues and things are starting to fail that shouldn't be failing at this age, you need to go to your general counsel attorney, let them know you have concerns about construction defects within your building. They will oftentimes bring in outside counsel as construction defect experts to evaluate those cases, oftentimes on a full contingency basis as well, so it's no money out of pocket to you. We have to hold the builders and developers in this state accountable for the product that they sell. If you're past the 10 years, it's all on us. Carter may open up the building and say, this was built wrong, this was built wrong, this was built wrong, this is gonna fail 10, 20 years early. Too late. This is now on us to fix. So for those of you in the younger buildings, please do consider that. I know that Carter will come out. They work in conjunction with the construction defect attorneys as well to do those evaluations. And it's possible that we can turn that around and make demand on those folks to help you defray the monetary costs. What other questions do we have in the audience, if any?
Can you go back, you said, or one who says that you do not look at items that are not responsibility of the condo, windows and doors specifically. So if you have problems with windows and doors that are leaking and maybe causing more problems in the building, that will not be addressed because of non.
Good, so we'll address that. The question was, so specific to windows, let's say, which the SERS only requires to be included if the association is responsible for the maintenance or replacement of those windows. So in the event that you are in a building that the owners are responsible for window replacement and the building is getting aged and you perceive issues with the windows allowing water intrusion down beneath the stucco and causing the damage that Carter's alluding to, what the board's job is to do is still to engage the appropriate professional, be it a Carter or a general contractor, to come and inspect those windows, to do essentially a pass-fail on them so that you can let the owners know it is now time to replace your windows. We have a lot of buildings in this state that are 30, 40 plus years old with owners still having original windows. Carter, roughly, what is the estimated useful life for a standard condominium window?
Yeah, so I'd say well-maintained windows, I've seen them be able to last, and of course it's not coastal, but be able to last 25, 30 years. But typically, especially if it's coastal, you'll usually end up having issues. As I said, most of the windows, unfortunately, aren't super well maintained, about 20 years, I'd say, is when you start to have issues of windows that have not been well maintained. That does not mean engineers are going to come by and say, we're at year 20, all these need to be replaced. It means that that's when you're going to start having issues if you do have issues. And I wanted to piggyback off your question real fast. Something that I typically recommend to a condominium, so I'm doing it right now with multiple condominiums, is, hey, we don't want to start the process of milestone because we're going to have to do it earlier. Typically what we recommend in that sense to get ahead of the milestone and the SERS is most of the time the SERS has already been done, but what we'll do is a property condition assessment with the capital reserve study. And then that way, you're ahead of the game. You're still getting a structural evaluation report. It's not a milestone, but it's still alluding to these are the issues that need to be solved. So then the idea, especially with these boards I'm dealing with right now with these condominiums, is by the time the milestone comes, everything's up. You're just easy inspection and then sign off, and you're good to go. So it's benefit, as I keep emphasizing, it's very beneficial to get the professionals involved, so then that way they see the issues, because the earlier you can start on it, the more you can phase things out, the more you can sprint things out, instead of having a mad rush at the end. You can come and say, hey, we have issues with parking deck, breezeways, these sort of things. Here's the priority structure. Here's what we hit this year, next year. And as I said, by the time milestone comes, you're all set pretty much.
Yeah. So just following up on the window question, please. If you are in a building where you are concerned that the owners are getting to end of useful life or have exceeded end of useful life for their windows, it is the board's job to identify that concern and then enforce the maintenance requirements in your declaration, just like you enforce the parking and everything else on the property. When the declaration says the owner has to maintain their unit, keep same in good working condition or first class condition or whatever your documents may say, it means that at the end of the useful life of a component, they need to replace their windows. By your owners not replacing their windows, they are compromising the integrity of that building for all of the neighbors. They are directly contributing to enhanced maintenance costs that are going to be felt by everyone in the building when you have to end up doing an exterior, reskin project and a waterproofing project. So the board is never out of the loop on anything having to do with your buildings. It is your job to ensure that the owners are doing their job. There is no one else that is going to tell them to do their job, only you. So if you need to spend money out of common expenses to do a general inspection of the windows in order to create a list and thereby a demand on the owners to maintain or replace their windows, then you need to do it. Because every day that we let go by where there's water potentially coming in through those windows, we are exacerbating the damage to the building and we are increasing our eventual maintenance burden. Yes, sir.
Yeah, does that extend to water heaters and plumbing as
Good
well?
question. Question about water heaters, typically a homeowner expense. Yes, if we are not monitoring those heaters, then we are waiting for them to explode, because half your community is probably going to be responsible and know they have to replace them every 10 years or so, and the other half is going to wait 20 years until the thing goes and floods out 4 floors below and say, oh, sorry, my bad. That's not the mode we need to be in. We can no longer afford to be reactive in this state because of our insurance issue. We have to focus our energies on being proactive and institute risk management policies for our building, which could include enhanced inspection. I cannot emphasize enough how much money you will save by spending $100 or $200 to have a general contractor or a plumber go and inspect all the units in your building and let you know on a pass-fail basis about hot water heaters, electrical panels, even toilet flushers and seals. And the amount of money that you will spend for a $15 toilet seal that fails and floods out your building is insane compared to the amount that you will spend sending a professional in to inspect that and telling your owner you need to do $100 worth of work in your building to save us $10,000. The boards just in this day and age have to accept that reactivity is no longer an option in this state and in this environment. You need to work with your attorneys and your management companies and your professionals to come up with a risk mitigation plan for your buildings that is going to allow you to enforce your declarations properly, keep your loss runs down on insurance, and keep your overall maintenance costs in line with your estimates, because it's these one-off events and these losses that are going to blow your budgets out of the water beyond where they already are. And this is just, this is the new world that we're living in, but we have to do it. Additional questions?
Does the board have the power to go in and fix it and charge it back to you?
So good question. Question was, can the board actually make the fix and charge the cost back to the owner? That is a declaration question. So if we don't have proper coverage in our condominium declaration, we need to go through and amend those provisions and inform our owners that we are trying to help you. And here's the best way we can do it. If an owner is not being responsive, then we will take on the burden and we will assess them for it. This is something the HOAs are accustomed to doing now, because most of their declarations have provisions that say we can go on and mow your lot or pressure wash your driveway, but condos typically don't have similar language within the declaration. So some of this may come down to actually amending our governing documents to align with better, safer practices to help with some of these maintenance issues. Other best practice tips are getting rules on the books to accommodate snowbirds and empty units. We want to ensure that empty units are checked in on, that water is shut off, that we have someone responsible going in to make sure that we don't have a problem. We risk losing insurance coverage if we do not timely report losses. And if a unit sits for 2 months during the summer unattended, and it's had an active water leak, and we've got mold issues and everything else, a small fix turns into a major fix, and we end up usually taking the loss. So having a rule on the books that says an owner has some responsibility to manage or maintain or monitor that unit is what ultimately, if necessary, and if the system doesn't work, allows us, though, to go back to that homeowner for reimbursement under a negligence theory, which the statute allows. So again, this is all strategy discussion that you need to have with the association attorneys, who will advise you on what the statutes require and allow and what your governing documents require and allow, and so that you can make a risk mitigation plan that actually meets the needs of your community and keeps costs down. Additional questions? Greg.
By statute, the milestone summary goes to the membership as well as is posted. But what do we do with the Sears? I can't find anything. No statute, no requirements. How we follow the Sears.
Right. So the Sears, First part of the question was just, Milestone does have disclosure requirements. CSRS report becomes part of the official record of the association, just like a standard reserve study or anything else that you do. So,
I keep it for.
Yeah, you keep it-
You, but I want to send it out.
no, you don't need to distribute it and send out. It's something that will be kept in the association official record, subject to inspection. If you want to give a copy out to be proactive, or certainly if you have a website, I would encourage you to post these things on the website, just in an effort to be transparent. But that just becomes a record of the association. Yes, sir.
I know that the Milestone has to go to the local building authorities. Now, we live in small communities on beaches, and I'm in South Pasadena. You Gulfport, 10-Gate Beach, Treasure Island, Madeira Beach, they're all small communities. How prepared have you seen these authorities to deal with these reports?
I haven't yet. Does anyone want to comment on that?
So each of the cities, South Pasadena has a building
Yeah.
inspector.
Yeah.
He is going to be sending out to your property manager a letter saying, please forward your reports to us. And that's